Well, good morning, folks, and welcome to GOA's Candidate Cam. We've been in hiatus for a couple of years. We decided to bring the program back. It's been a success in the past. And today we have a special guest. And this program and this format is designed to allow you to ask some questions of our endorsed candidates and give an opportunity for that candidate to talk to you about what makes them so special. And so today we have in our community, people know Josh Prince. He's a pro Second Amendment attorney. He's done a lot of good work for gun rights in Pennsylvania and elsewhere. And, within our community, people know him pretty well, I think, here in Pennsylvania. But, outside this community, maybe not so much. Maybe there are other people watching this broadcast that don't know Josh. So, I'm Val. I'm the Pennsylvania director for GOA and have been so since 2019. Josh and I have worked together on multiple projects. It's been a pleasure. And Josh, just take a few minutes to really briefly to introduce yourself, maybe give a little bit of your background and, anything else you might want to say before we start into some of the questions.
All right. Well, thanks for having me, Val. I really appreciate it. For anyone who doesn't know anything about me, I'll just quick go over personally. I was born and raised in Berks County, Pennsylvania. I then went to McGill University in Montreal, where I double majored in political science and world religions, graduated with honors, came back stateside, went to Widener University Law School, where I graduated with honors as well as a member of the Law Review. More recently, about 2.5 years ago, I had the opportunity of a lifetime. I got to marry my best friend and the love of my life, Jessica. And we just found out that we're going to be having a baby girl in September. So we are completely stoked about that, bringing another conservative young lady into the Commonwealth here. Beyond that, in relation to my professional life, I've spent my entire career defending our rights in the state and federal courts. I am most well known for my Second Amendment advocacy, but I've handled all forms of constitutional issues: equal protection, due process, religious freedom, freedom of speech, what constitutes reasonable suspicion of criminal activity, you name it, pretty much handled it. I have not handled a Third Amendment issue, though, thankfully so. For anyone who knows, that's quartering of troops in one's home. So thankfully, that's not an issue we've had to deal with recently. Beyond that, I was also at the tip of the spear fighting the COVID mandates. A lot are unaware that the original mandate actually forced the closure of all law firms, so no one could challenge the executive fiat. I was the attorney who filed a special petition with the Pennsylvania Supreme Court, referred to as a King Bench application, where you basically ask the Supreme Court to immediately hear a case because it's of such paramount importance. Within 48 hours of filing that, I like to say Governor Wolf had a first-of-a-lifetime epiphany, found law firms to be essential, allowed to reopen, used the same mechanism to get our gun dealers reopened here in Pennsylvania, and then went on to represent so many small businesses that were being fined by the Wolf administration. As just one example, a lot of people heard of here in Pennsylvania is Taste of Sicily. They were fined close to $100,000 by the Wolf administration. We got all those fines thrown out. We then went on to represent a bunch of parents and students, as well as some school boards and school officials that wanted the parents to make the decisions in relation to masking and vaccinations of their children, not the school district. So that's, in a nutshell, a lot of my background. Obviously, I've handled a lot of different firearms-related issues, cases, but I have handled, everything from class actions to mental health cases and everything in between, even some work comp and Social Security disability in my past, as well as unemployment compensation. So I do have a breadth of experience.
Yeah, it certainly sounds like it. Absolutely. Now, as a Gun Owners of America endorsed candidate, can you elaborate on your interpretation of the Second Amendment and also Article 1, Section 21 of the Pennsylvania Constitution, and how it applies to Pennsylvania law? And how might your interpretation differ from that of your opponent?
Sure. So, under the judicial canons, a candidate for judge can never say how they might rule in any particular situation. That being said, while a lot of candidates will hide behind the judicial canons and say that they can't even state their own personal views, that is not true. You still have, or any candidate still has, a First Amendment right to state what their personal views are if they want to. But it's important to understand those personal views must get checked at the courthouse doors. And that's a major tenet. We may get into it a little later, but that is a major tenet of my campaign of getting the politics out of the courtroom. In relation to the Second Amendment and Article 1, Section 21, I believe these are natural rights. And I think when you actually look at the Pennsylvania Constitution, it's more explicitly clear. And it's not just simply based on Article 1, Section 21. Rather, it's a provision in Article 1 that no one talks about. It's something I've argued in a number of my cases. The courts have yet to actually issue any decisions addressing it. And that is Article 1, Section 25, which states that all the rights enumerated in Article 1 are accepted out of the power of government and are inviolate. I don't
Yes.
think you can get much stronger language reminding everyone that these are not rights given to us by our government. They are innate rights. They are natural rights, which cannot be, divested of someone. They may be able to elect not to utilize their rights if they want to, but there isn't a government around that has the authority to divest someone of those rights. And that is my own personal view of both the Second Amendment and Article 1, Section 21, in conjunction with Section 25. In relation to my opponent, he spent his entire career representing the Department of Environmental Protection against the people. I'm very honored to say I have never represented the government against the people. The only times I've quasi-represented a political official would be when the former Perry County Sheriff Nace was sued by the county auditors wanting all license to carry firearms applicant information. A lot of people are unaware that here in Pennsylvania, all that information is confidential. It's not subject to disclosure. It's actually a felony of the third degree to disclose it. There is also civil penalties associated with disclosing it. And so when he was sued, I offered to represent him pro bono because I saw that if we didn't step in and stop it there, it was going to be the domino effect where every county and every local group across Pennsylvania would start to be disclosing this license to carry information. And we later learned that there was a county auditor or actually someone who had the ear of a county auditor that wanted to know who all had licenses to carry in Perry County, which is where it stemmed from. So very honored to have represented Perry County Sheriff Nace in that issue and be successful. My opponent has never litigated a Second Amendment issue. It's really interesting. He's never actually litigated an issue on the merits to a conclusion in the Commonwealth Court. Every time that the Department of Environmental Protection sues one of his clients, because now he is private practice, he enters into what are called consent decrees, whereby he has his client agree to what the DEP wants. And recently, during his PCN interview, he actually stated that he still goes in and trains DEP attorneys. So he's actually training the attorneys who are going to go after his clients. So it's really perplexing and concerning in the same regard, because as I said, I haven't seen any cases where he's actually litigated an issue, said that, the government action is either unlawful or unconstrained or just unconstitutional. And that's concerning to me because obviously with the Commonwealth Court, and maybe we'll talk more about that in a minute or so, but with the Commonwealth Court, it is a court of direct government oversight. And all those types of issues are those that come before the Commonwealth Court.
Yes. Well, thank you for that. That's, and speaking of the Commonwealth Court plays a significant role in shaping Pennsylvania's legal landscape, as you just mentioned. And one of our questions that we ask on our survey is about judicial philosophy. So what is your judicial philosophy, and how do you believe it will impact your decisions on the court? I know you may not be able to say those kind of things, but just your personal opinion.
Sure. Well, and my judicial philosophy is only to ever uphold the law as written in the Constitution as intended, period. If you don't like what the law says, there is a mechanism by which we can change it. That is petitioning your representatives to have the law changed. It is not for the courts under the guise of quote unquote interpretation to basically make the law whatever they want it to be. And we've seen that unfortunately too frequently. In fact, I'm dealing with a case right now that unfortunately was decided against me. The only case in the past 6 years I've lost in the Commonwealth Court, where the statute says that the Pennsylvania State Police shall perform a background check instantaneously. The General Assembly utilized the word instantaneously in that statute for a good purpose. And so what ended up happening is it got assigned to Judge Seisler, who has now retired, and that's the seat I am running for, who defined instantaneously as a reasonable amount of time, the reasonableness to be determined by the Pennsylvania State Police. So the agency set to enforce the statute gets to decide whatever is reasonable. And that's absolutely absurd. You could go down the street and ask the first 12 people that walk past you, what's a definition for instantaneously? And they're not going to tell you, I think a reasonable amount of time, and whoever is enforcing it gets to decide what's reasonable. No, that's absolutely absurd. And that's the type of political, non-judicial decisions that have truly eroded the confidence of the public in the courts. So again, getting back to judicial philosophy, that is my philosophy, is to get those political related decisions out of the courtroom. Now, I also recognize that that means if I am blessed with this opportunity, there are likely going to come times where I'm going to have to issue decisions that I personally disagree with, because that's what the law says. It may be the fact that the litigants before us could have raised a constitutional issue that may have resulted in that law being found unconstitutional, but they didn't. And it's not for me to, what we call sua sponte, meaning on my own or on the court's own, to raise those issues. That is the exact type of thing that the public is extremely disgruntled with in relation to the judiciary. A good judge only decides the issues directly before him or her, and that is what my judicial philosophy is.
Thank you for that. Well, now let's get to something that's really, really important to gun owners. I know for me at GOA and for GOA members, and I recently met with the Attorney General, Dave Sunday, and we stressed this to him, that one of the top issues in Pennsylvania is preemption. And the Commonwealth Court often deals with cases involving these local ordinances related to firearms, and you've been a champion for statewide preemption. So please let our viewers know why field preemption related to firearms is so important in Pennsylvania, and then elaborate your own litigation experience in this area.
Sure. So, as you noted, and thank you for the kind words, I have handled the supermajority of preemption issues here in the Commonwealth. And we just recently submitted an amicus brief in support of GOA's case before the Pennsylvania Supreme Court, arguing for field preemption. And it's necessary because although we have also express preemption in 18 PACS section 6120, there have been arguments in the past that it's not all encompassing, even though when you actually look at the debate in the General Assembly, it was clear that they were denying all local forms of government any power in any manner to regulate firearms and ammunition. And that's for good reason, because if you have a patchwork of laws across this Commonwealth, it will only ensnare law-abiding citizens who have no way of knowing what the law is. And just think about our highly mobile society, all the different local municipalities on a daily basis that you drive through, going to work, going to the grocery store. Think if you needed to know if each and every one of them had their own regulation of firearms and ammunition. And that's extremely disconcerting if that were to exist, because of the fact of the chilling nature it would have on our ability to defend ourselves. Because at that point, people would be concerned, well, I don't want to violate the law. I don't have time to go into research the law. What is the current state in this municipality? And so the individual may end up leaving their firearm at home and not have it for use in defending themselves if, God forbid, a self-defense case would arise. So that's why field preemption is so important. It's the major argument we made, that based on the breadth of Pennsylvania's Uniform Firearms Act, as well as a number of other statutes, everything from our game code to our range protection statute and beyond, that the General Assembly has made clear that they are the only ones, and that makes sense, to regulate firearms and ammunition in this Commonwealth. So there's one code section that the people can look at to know if their conduct, or desired conduct, is lawful or not. So I think that's really important for field preemption purposes. And some of the cases I've handled, I've handled everything from an individual who had their firearm stolen from them, and then their license to carry revoked as a result, even though they are the victim of a crime. And then beyond that, the city of Philadelphia decided that they were going to bring up charges, civil charges, against them for not notifying the city of Philadelphia soon enough that their firearm was stolen. And so, nothing like re-victimizing a victim of crime. It's absolutely absurd. And nowhere else do we see any such law where we basically re-victimize a victim of crime or require a victim of crime to report something. And so I represented Mr. Armstrong successfully before the Commonwealth Court in having them say, no, this is preempted. You can't regulate in this manner, Philadelphia. There's a lot of other cases I've handled. One of the first cases I handled was City of Erie versus Dillon et al. There was
Mm-hmm.
actually a very, everyone was, humble and peaceful at a rally in downtown City of Erie, where they had, firearms strung over their shoulder or on their hip. And the city decided to go after them and prosecute them criminally for just merely having those firearms on their persons. So at the same time that that was being criminally processed, we also filed a civil action seeking an injunction against it, and was successful with the Commonwealth Court issuing finally direction to the Court of Common Pleas in Erie to issue an injunction enjoining enforcement of that ordinance as it violated preemption, and the
Right.
fact that there just wasn't any basis in the law given the conduct for any type of charges. And that was one of the very first cases. That ordinance also affected discharge, and the Commonwealth Court said both the carrying and discharge are preempted. Then went on in Lower Marion County, they had a similar type of ordinance where they said couldn't be in any of their parks with firearms, couldn't discharge them, and the Commonwealth Court once again affirmed, saying these are preempted. These ordinances are unlawful. And I mean, there are so many different types of preemption case. We even have one currently in Montgomery County that has one aspect to it as a preemption, but in essence, the county sheriff decided to implement his own policy that he could go without a warrant, seize anyone at a county federal firearms licensee, anyone who's of an employee of that business, ask whatever questions and they had to respond, as well as demand any documents and they had to produce them. So
Wow.
obviously that's beyond the ability of a sheriff, especially when we start talking about waiving constitutional rights, that he can all of a sudden bless himself with the power to come in without a warrant.
Yeah,
And
really.
that case has been on appeal. Well, not on appeal, excuse me, before the Commonwealth Court for a little while now. We had oral argument, and it was en banc, meaning in front of the entire Commonwealth Court. And it was very interesting because even Judge Wojcik took an opportunity when the Assistant Attorney General was arguing the case to say, counsel, it's been a little while since I've been in law school. I haven't done criminal law recently, but I seem to remember that if you wanted to obtain a warrant, you didn't have to tell the person that you were getting the warrant against that you were getting the warrant. Is that still the case? And the Attorney General says, yeah, that's correct. He says, okay, so explain to me why you can't just get a warrant. Oh, that I understand, you're right. It's just too inconvenient.
Oh
His jaw
dear.
literally dropped down. And I mean, no one in the courtroom could believe that she literally just said that. So, like I
Oh, it's
said,
unbelievable. Yeah.
it's been very interesting. We have some constitutional challenges there to that regulation as well.
Yeah, you've been involved in a number of these preemption cases, and we GOA thanks you greatly for the amicus brief that you filed on behalf of your clients. Another question, and this has come up in the debate between you and your opponent in Commonwealth Court, is this idea of judicial temperament. Judicial temperament would be crucial for a Commonwealth Court judge. So, how do you define judicial temperament, and what steps will you take to ensure to maintain it on the bench?
Okay. Those are great questions. And just to start, because some people may not be aware, the Commonwealth Court is the only court in the nation that acts both as a trial court and an appellate court, depending on the legal issue before it. So anytime you sue the Commonwealth officer or agency, it actually acts as a trial court where it takes in evidence, hears testimony, makes credibility determinations, issues findings of fact, conclusions of law. Whereas anytime a Commonwealth agency issues a decision you don't agree with, let's say the Pennsylvania Department of Revenue contends that you owe a tax and you disagree with that, any appeal of that determination goes up before the Commonwealth Court. And that's because the Commonwealth Court was designed to be a court of direct government oversight, which again is the only one of its nature in the nation. With
Mhm.
regards to judicial temperament, when we hear temperament, I think most everyone's mind goes to demeanor. And obviously that's an aspect of judicial temperament. You need someone who's cool, calm, collected, going to be respectful to both attorneys and litigants that are in their courtroom. And that becomes important, especially with the Commonwealth Court, because again, remember, it does act in certain occasions as a trial court. But I think it goes much deeper than that. I think it includes things like fairness, humility, consistency, a deep respect for the litigants that are before you and for the law, only ever upholding the law as written, the Constitution as intended, never weaponizing the law or allowing it to be weaponized against a person or a group of people, and also remembering that at the end of the day, a judge is bound by the law no different than anyone else. They are no different. I know that unfortunately, there are some individuals who get elected to judge and over years get what they refer to as black robe disease, where they seem to forget that they are not above the law, that they are no different than anyone else, and that they are there to be impartial. I really think, it is important that we get the politics removed out of the courtroom and that the judiciary go back to only ever upholding the law as written in the Constitution as intended. Because even if you're a sitting judge and you don't like what the law says, you have the same right as everyone else to petition your representatives to have it changed. It is not for you to decide under the guise of interpretation to be able to change it. And I really think that in a nutshell is true judicial temperament, ensuring that the law is only equally and fairly applied to everyone that comes before you, and that if you see something wrong, you say something about it. I still think about the Luzerne Kids for Cash situation, where a lot of people don't realize that although there were hundreds of reports from attorneys, law enforcement, everyone else complaining, saying that this was going on, they weren't heard. It wasn't until another elected official got into some trouble and said, hey, if you go easy on me, I have information about these judges in Luzerne that are taking kickbacks to put kids in these certain facilities. That's the only way it came out. That is so disconcerting to me that no one else, knowing this going on, stepped up. And that's a major concern of mine. And I can tell you that if I am blessed with this opportunity, if I find out that there's anything like that going on, any shenanigans in the courts, if it's not corrected, I will make sure that the public becomes aware of it, because it is disconcerting to know that there, in the past 2 years, were over 2,500 complaints filed against judges, and only 2% have been reviewed.
Wow.
I know that there's a lot, of complaints that get filed vindictively, especially in relation to family law matters, because generally someone always feels that they're on the losing end. So I know that there are, a number of those complaints that probably don't have any basis in the actual law. But nevertheless, that sheer number and only 2% have been reviewed, that's really concerning. That's something that we need to address, especially the fact that the Pennsylvania Supreme Court has significant control over the Judicial Conduct Board. And I think we really need the General Assembly to pass a law making an independent body that reviews judicial conduct complaints and have the courts completely out of it.
That is a very interesting idea. And thank you for answering that question on judicial temperament. We really greatly appreciate that. Now, this next topic is something I've run up against quite a bit. That's when the GOP endorses a candidate that maybe Gun Owners of America doesn't think may be the best candidate. And we run into this all the time. And so particularly in primaries, and Pennsylvania is one of just a few states left that has closed primaries. So this is a real opportunity for us to shape elections. We get involved in primaries. We really want, and again, we're a focused issue organization, so we're focused on Second Amendment, Article 1, Section 21, gun rights. So that's what we focus on, and we try through surveying candidates. It's an imperfect process, I know, but through surveying candidates, we try to pick the best person for the job. That's what our primary concern is. And that doesn't always line up with who the GOP thinks is the best person. We know that, right? So your opponent has the backing of the Republican Party. Because of your record, GOA has endorsed you for Commonwealth Court instead of your opponent for the reasons I mentioned. I mean, you're the Second Amendment advocate, scored great on the survey. There was no question who the logical choice for us would be. So why should GOP voters put their support behind you in the primary instead of your opponent.
Sure. Well, and thank you again for GOA's endorsement. I am extremely grateful for it. I know it's not an easy process to go through. Just to real quick to start, so everyone remembers, the purpose of the primary is for the people to be able to select their candidate. And that has been lost on both political parties. Real quick, for those who don't know, back in 1842, it was first the Democratic Party that thought that it would never win an election again, because they were using the convention process whereby the party selected the candidate and that's the only person that the people had to vote for. And so the members of the Democratic Party felt disenfranchised by the fact that they had no say, their voice didn't matter, and they said, we're not going to go out and vote anymore. It was because of that, in Crawford, Pennsylvania, that the Democratic Party came up with the direct primary process, whereby the party agreed to stay out of it in the primary, that whoever the candidates were, the people, their members, got to support whoever they wanted. But then after the primary, whoever won, everyone coalesced behind. And it was interesting that less than 2 decades later, the Republican Party found itself in the same situation in 1860, and it too elected to adopt the direct primary process. And it has forgotten, both parties have forgotten about their covenant with the people, that they are to stay out of the primaries. They basically want their cake and eat it too. They use endorsements as a way of basically returning to the convention process without having to tell the people, we're stripping your voice away from you, we're leaving the direct primary process and going back to the convention process. That is exactly what both parties want, and it's extremely upsetting. A lot of people don't realize the background to the direct primary process, and that constitutionally, we are not required to have a primary. That is at the election of the parties. With that being said, if you actually look, and Charlotte Schaefer of Adams County, she's the chair there, had actually put together a spreadsheet of the success rate of the PA GOP in endorsements over the past decade. If you leave when Trump ran in, their success rate is 39%. If you remove Trump out, it's 17%.
Wow.
Even if, we give them the benefit of the doubt and say somehow Trump didn't have any impact whatsoever on those races, 39%, you can your CEO or your head coach. That is not a success rate.
Right.
And it's truly more likely around 17%. And that's because of the fact that they want the candidates that they can control. They want a candidate for judge who they know they can pick up the phone, call, and say, hey, look, we know the law doesn't provide for this, but this is the outcome we need here. And that person will realize they would not be in that position but for the party. And that's not me. They know that. That's why they see me as such a threat. In fact, I was halfway through the endorsement process, and my intent was actually, if I did receive the endorsement from the PA GOP, to decline it and say it is time to return the voice to the people, with the hope that others would do it. But I was halfway through the process before an opponent showed up. And when asked how he came to run for this seat, he said, oh, I got a phone call. They said, you got a phone call? Yeah, I got a phone call and told to run. And I didn't understand why he didn't have a website, didn't have social medias until about 6 weeks ago. Well, a couple weeks ago, I found out the answer to that. He was promised that if he ran, he'd get the endorsement and I would drop out and he wouldn't have to do anything until after the primary.
Wow.
Now, to think that even if you are the sole person running for a spot, that you're going to throw 3-4 months away of a candidacy where you could be out getting your name known across this Commonwealth, that's absolutely absurd. But that's the type of things that were done. And we actually had written a number of articles, and you can go on princeforjustice.com. If you go into our news section, you may have to scroll back a couple pages, but we had an article about the threats and bribes going on to the state committee members. We knew what the outcome was going to be before the vote based on that. And I actually wrote a private ballot process, which is really no different than how we vote when we go in, on May 20th, for example, to vote. But the PA GOP would not allow it. Instead, they demanded a roll call vote where each individual had to stand up before the entire body and announce who they were voting for. And the reason for that is they needed to know whether their threats or bribes had carried through and to whom they still owed their promises. So it's really disconcerting that the party that actually brought us a private ballot process when we go to vote in person is actually the party opposed to it in their endorsement runs. So that may have been more information than you wanted, Val. I apologize, but
No, I mean, I think the background is very important to understand, especially the historical background. I greatly appreciate that. And it's just, but what makes you different? What makes you different than the GOP's endorsed candidate? Why should our viewers, people watching this broadcast, why should they vote for you?
well, I always tell people you don't have to listen to a single word I say. Look at the cases I've litigated, look at the arguments I've made. You'll know everything you need to know about me and my candidacy. Over the past 6 years alone, and just in front of the Commonwealth Court alone, I've litigated 13 cases before it. Of the 13, I've already won 10. Two are outstanding decision, but based on how oral argument went, I expect to win those two. The one that I lost that I mentioned earlier is up before the PA Supreme Court. And even based on how our liberal nature of our Supreme Court, based on how oral argument went there, we expect that loss to be reversed. So I may end up with a 100% track record before the Commonwealth Court. Now, most appellate attorneys will tell you if you have an appellate attorney who's successful 30-40% of the time, you have a really good appellate attorney. I don't mention that I may end up with a 100% success rate to be boastful. Rather, the reason I mention it, it shows that my arguments are grounded in the law and the Constitution, that I'm not trying to twist the law into a pretzel to meet whatever ends I want, and the judges agree. And the Commonwealth Court's extremely important because there have been instances where the court's gotten it wrong. And in fact, I am very blessed to have been the attorney in the city of Harrisburg case where it involved the firearm preemption issue, but the initial issue was standing and what was necessary to basically argue in a complaint for purposes of standing. And the Commonwealth Court, in a case that NRA had litigated, had previously found that the NRA did not have standing, and it was a hurdle to get over that type of precedent absent being criminally charged for violating an ordinance. And so I had long said under the Declaratory Judgment Act, that was an erroneous decision. And that was one where actually then Judge Brobson in the NRA case had written a dissent saying we got this wrong. And so in the Harrisburg case, I had the opportunity to go in front of the Commonwealth Court en banc, again, meaning in front of the entire court, which is where they could overturn that precedent. And then Judge Brobson, writing for the court, overturned that prior precedent, saying that no, this was sufficient. Someone doesn't need to be criminally prosecuted in order to challenge an ordinance. That case was then appealed up by the city of Harrisburg to the Pennsylvania Supreme Court. And the Supreme Court said, you know what? You got it right this time.
Excellent.
So,
So,
those, go ahead.
Plenty of experience, right? I mean, so you would say your experience is there as a litigator. I mean, for us, your record on the Second Amendment litigating on behalf of the rights of gun owners across the Commonwealth and in other states too is apparent. So would you say it comes down to an issue of experience in litigation?
As well as the fact that I've only ever represented the people. And the true purpose of the Commonwealth Court at its inception was to keep government in check. I actually am the only candidate who has a proven track record of doing that. My opponent, as I mentioned earlier, now in private practice, when DEP sues his clients, he enters into consent decrees where he has his clients agree to exactly what DEP wants. He hasn't once actually litigated a case, said, this law is unlawful, it's unconstitutional, anything of that nature. He just gives in. And that's what we see time and time again. And I'm extremely disconcerted with the PA New Green Deal that will likely be going up in front of the, Commonwealth Court at some point. And what may result from that. He still goes in and trains DEP attorneys. And one of the real disconcerting things that he also said during his PCN interviews, he's asked, what is your judicial philosophy? And he says, well, you start with the intent of the constitutional provision. I'm like, okay, but where's he going from here? And he says, and then you have to decide if it still makes sense. I'm sorry, that is a living, breathing document response.
Wow.
And I love when people ask me, Josh, do you think the Constitution was intended to be a living, breathing document? And I say no. And in fact, I can just ask you one question that dispels that our founding fathers ever intended for it to be. And they'll say, well, what's that? I said, if our founding fathers intended for the Constitution to be a living, breathing document, why'd they include an amendment process? It'd be wholly unnecessary. It would just simply evolve, live, breathe, evolve. It wouldn't need that amendment process. But our founding fathers included an amendment process because they knew the Constitution was static. And if there ever came a day where a provision of it no longer applied or we wanted to add to it, we had that capability. But it had to be the rigorous process of amending the Constitution. And I think it's interesting that with the 18th Amendment, we saw when we wanted to ban alcohol across this country, we believed not that long ago you had to go through an amendment process to be able to do it. And when we
Right.
decided as the people that we no longer thought it fit our purposes, we had to go through the amendment process, the 21st Amendment, to repeal it.
Right.
So I just think it's, really interesting when you look at my opponent's background and the things he said. They are not conservative in nature. They are not simply upholding the law as written in the Constitution as intended.
Well, we know that the Commonwealth Court handles other things besides local preemption issues and constitutional issues surrounding that related to firearms rights. They handle a wide range of cases, including those related to environmental law, government regulation, and here's a big one, election law. So what do you think about that? And what would you like to say about those complex legal issues?
So I really enjoy complex issues. I will say that a lot of times the cases I litigate are ones that people say, oh, there's no way to win this. No different than when the delays were happening with the background checks. Everyone said, oh, there's nothing that can be done about it. And I said, well, hold my beer. And so that's when I sued the PSP commissioner and initially did get an injunction against him. I love the more difficult cases. I think we need to have someone from a rural community that understands what it's like to live rurally, what the farms are like. There's a lot of assaults on farmers because of spreading manure, things of that nature. And I have experience. I'm also the chairman of the District Township Zoning Hearing Board, where, we hear a lot of zoning related cases. All of those types of cases would also go up on appeal to the Commonwealth Court at some point if appealed up far enough. So I really look forward to that. And I think what all your viewers would see if I'm blessed with this opportunity is I would ensure that I understand the law that is before me, understand the complexities and the interplay that a lot of people overlook, judges especially as I know between federal and state law and the firearms laws. And ensure that we get the right decision the first time. One of the unique aspects of the Commonwealth Court is every single decision, even if it's just a panel of 3 judges, gets circulated amongst all 9 judges. And any judge who has an issue with it can basically say, hey, I have a problem with this decision, even though I wasn't on the panel. Maybe we need to hear this en banc. Maybe we need to have new argument, something of that nature. And I think I would really utilize that process to make sure we get it right the first time so that we don't have a situation like we had in the NRA case regarding standing that prevented so many cases for so many years from challenging those unlawful and illegal ordinances.
All right, gotcha. Thanks for that. So we're getting towards the end here. So I'd like to usually end the candidate cam with I call a parting shot. So what's one takeaway, just one takeaway you would want our viewers to know about you right now?
In one sentence, I can sum up my career as an unparalleled career of holding the government accountable to the law and the Constitution. And if that resonates with you, as well as getting the politics out of the courtroom, then I hope you'll vote for me on May 20th.
Well, thank you. Thank you very much. So this Matt Contreras says Prince for Justice is the only choice for Commonwealth Court judge on May 20. Thank you, Matt, for that comment. And of course, as everyone knows, this is Josh Prince. Josh Prince is GOA's endorsed candidate for Commonwealth Court. We have a primary coming up on May 20th, so make sure you get out to vote. Thank you for being with us today, Josh. We greatly appreciate it.
Thanks for this opportunity, Val. I appreciate it.